good morning, afternoon, or good evening, depending on where you are joining us from. Welcome to today's webinar on the crypto services licensing in the UAE. My name is Iryna, and I'm a virtual legal officer in Legal Notes. Legal Notes is an AI-powered platform that helps founders solve their cross-border legal matters with a single point of contact and backed by a network of vetted legal partners across 70 plus jurisdictions. We at Legal Notes continuously contribute to our resource center on the platform where you can find free educational information on many startups' hot topics there, including the company setup process, fundraising, key regulatory considerations, privacy matters, and many more. Additionally, we welcome you to like this video and subscribe to our YouTube channel, where we explain in simple words and with visuals tech and in particular Web3 sector's legal considerations. Today, we will dive deep into the regulatory frameworks governing virtual assets in the UAE. We'll cover the licensing requirements across countries, key jurisdictions. Which is the Virtual Assets Regulatory Authority, VARA, in Dubai, the Dubai Financial Services Authority, DFSA, in DIFC, and the Financial Services Regulatory Authority in Abu Dhabi Global Markets. We are not covering the Securities and Commodities Authority and Central Bank of the UAE in this webinar. This is a regulator on a federal level that applies to some security tokens and stable coins. We might have a separate session to cover this regulator and the frameworks dedicated to those tokens later on. So we'll start with overview of the UAE regulatory landscape and VARA as a licensing authority. UAE has steadily built out its legal infrastructure for digital assets from federal law in 2018 that recognized virtual assets and established AML CFT obligations for service providers to cabinet resolution that exempted most virtual asset transactions from the UAE's 5% VAT. That is effective since November 2024. So this latest action offering economic incentive shows the commitment to become the world's hub for virtual asset services and development. The UAE is a federal jurisdiction with multiple regulatory bodies, as we saw on the previous slide. Here it is. One of the UAE's key advantages is its dual-tiered regulatory structure. The crypto oversight operates at both the federal and the emirate levels, coordinated between several bodies. And the country has 7 emirates and numerous free economic zones in each emirate. Each free zone and onshore companies are subject to licensing from distinct regulatory authorities. And when it comes to VARA, it governs the licensing of virtual asset service providers in Dubai for mainland companies and for all free zone companies except DIFC free zone, Dubai International Financial Center free zone. VARA was established under Law Number 4 in 2022 by Dubai government, and it's known to be the first dedicated virtual asset regulatory authority in the world. On the screen, you see 7 license types offered by VARA. along with the industry native language examples. Some of the activities can be combined depending on the project features and qualification of those features by the regulator, except for the custody. Custody is always a separate licensed activity and may require a distinct legal entity to handle custodial services. Some wallet services that are non-custodial, for example, purely client-controlled keys, might not require a full license, but can still fall under VARA's NOC requirements, non-objection certificate requirements. VARA offers an interesting approach to token issuance activities. Token launch activities are divided into two categories. Category number 1 includes fiat referenced virtual assets and asset referenced virtual assets. These must obtain a VARA license before issuance begins. Category number 2 covers any virtual asset issuance that is neither category 1 nor exempt, and no license needed from VARA prior to issuance of tokens if the tokens are closed loop and non-transferable and basically redeemable. Utility tokens that cannot be exchanged for virtual assets or fiat are exempt from licensing and supervision. Important to note that VARA has a ban on anonymity enhancing tokens. And on the next slide, we'll go through a step-by-step process on how to obtain VARA license, how to apply for VARA license. So first of all, you need to be incorporated in Dubai outside of DIFC free zone. The process of VARA licensing is quite complex. VARA encourages early contact before filing the initial disclosure questionnaire. Many applicants arrange introductory or scoping calls with VARA's licensing and authorization team to confirm whether their planned activity falls under VARA's licensing scope and clarify which license category or categories apply. Then the team would need to discuss potential structuring issues, for example, whether the custody element of the product or service must be separated into another entity. Often, the application process is done through an appointed legal or consulting representative rather than directly by the founders because of the complexity of the documentation that is to be submitted and the whole process. The first step would be the legal entity registration pre-approval. So applicant must be a legal entity established in the Emirate of Dubai on the mainland or in any other free zone outside of DIFC, as we mentioned. And many free zone authorities assist founders in the communication with VARA. So if you're planning to be based in one of the Dubai free zones, you can communicate with the free zone authority about assistance they can provide when it comes to obtaining any specialized licenses. Next step is a submission of that initial disclosure questionnaire to VARA. Then applicants pass fit and proper assessment, which means that VASPs must appoint at least 2 UAE resident full-time employees of sufficient seniority who shall be responsible for the VASP's compliance with all legal and regulatory obligations. This would include full KYC, CVs, police clearance for directors, senior management, and significant shareholders, financial soundness checks on personal and on corporate level. Then the applicants also submit a business plan. The license applicant must include a detailed description of that business model, product, service, target market, projected transaction volumes, operational and governance structure charts in that business plan. And then, if all those documents are all submitted properly, VARA issues pre-approval. At the pre-approval stage, applicants pay 50% of the licensing fee and will cover the fees soon. And at this stage, the applicants obtain provisional approval before starting any commercial activity. With this provisional approval, the commercial license, not the actual crypto license, just the commercial license, which is the UAE's equivalent of an entity incorporation certificate, can be issued by the respective authority or Department of Economic Development and Tourism of Dubai or the Free Zone Authority. The remaining list of documents needs to be submitted to VARA following this provisional approval. And that includes corporate documentation, certificate of incorporation, or so-called commercial license in the UAE, memorandum and articles, shareholder and UBO details. Compliance and risk frameworks would include AML-CFT compliance policy aligned with UAE laws, risk management framework covering operational, cybersecurity, market and liquidity risks, and sanction screening procedures. When it comes to technology and security requirements, IT architecture overview, cybersecurity policy, and data protection controls will be analyzed by VARA. Incident response and disaster recovery plans will also be reviewed. When it comes to capital requirements, we'll also cover it on a separate slide, but the proof of meeting VARA's minimum paid-up capital requirements is to be submitted at that stage after the provisional approval, and the capital requirements vary by the license type. Additionally to that, insurance, professional indemnity insurance is applicable. And if the company is outsourcing any parts of the processes to third parties, any third-party arrangements involved will have to be disclosed to VARA, like the tech providers, custodians, KYC vendors, and other relevant contractors. When it comes to client asset protection measures, the applicant will have to submit a proof of segregation of client assets from company funds, if that is applicable. Custody arrangements and safeguarding procedures will be analyzed in that case. Applicants commit to maintain records for at least 8 years, and that's on the transaction records, and to submit financial compliance risk periodic reports, and to comply with inspections and audits by VARA. And finally, at this stage, after the submission of all those documents and policies, the remaining 50% of VARA's application fee is to be submitted. And here we have a slide with some ranges of fees and ranges of minimum paid up capital required. So the fees you see on the screen are VARA fees only and are exclusive of the third-party legal advisory service provider fees. Application fee starts from 40,000 dirhams, which is approximately $10,000 for advisory, transfer and settlement services. And those fees reach 100,000 dirhams, which is close to $27,000 for broker dealer, custody, exchange, lending, borrowing, asset management type of services. Annual supervision fees, which are equivalent of renewal fees, are double of the initial fees and are 80,000 dirhams for advisory and transfer services and 200,000 dirhams, which is close to $54,000 for other services. VASPs must maintain paid-up capital at all times, either as the fixed amount or a percentage of fixed annual overheads, whichever is higher, according to the business activity license. For example, exchange services applicants' capital requirements are higher of 800,000 dirhams, which is around $217,000 or 15% of the fixed annual overheads with a VARA licensed custodian partner. Otherwise, if you don't have VARA licensed custodian partner, your capital requirements would be higher of 1.5 million dirhams or 25% of fixed annual overheads. Custody services, minimum paid up capital would be higher of 600,000 dirhams or 25% of fixed annual overheads, whichever is higher. If licensed for multiple virtual asset activities, VASPs must hold the required capital for each activity, calculated on exclusive fixed overheads per activity and reconciled monthly. Important to note that capital must be held in a UAE licensed bank trust account with VARA as a beneficiary or in a surety bond naming VARA with no expiration. Quite complex, so it's better to engage an experienced legal provider early in the process to avoid any delays in the licensing. Now we will move to the overview of the Dubai Financial Services Authority, crypto licensing in DIFC. DFSA regulates financial services in DIFC free zone. It's their dedicated regulator, independent regulator. And the DFSA regulates virtual asset service providers through its existing financial license categories with specific permissions for crypto-related activities under crypto token regime, which is effective there since November 2022. So these are the DFSA financial services suitable for crypto token sector. And additionally, when you are looking to apply that crypto token regime, there will be an additional authorization and fee applicable on top of the standard licensing fee for general financial services. Obtaining a DFSA license to operate as a VASP in DIFC also involves a thorough authorization process, ensuring the applicant can meet DFSA high standards for governance, resources, and compliance. Key application requirements and steps include the application, the incorporation in the DIFC, a dedicated DIFC company with its own board and governance must be set up. Firms should first engage the DFSA through an initial inquiry. The DFSA requires a pre-application form via their e-portal outlining the proposed crypto business model, products, target clients, and the specific financial services permissions sought. Applicants must demonstrate that shareholders, directors, and senior management are fit and proper and have relevant experience in crypto or financial services. Key roles like CEO, finance officer, compliance officer, money laundering reporting officer need to be identified. And these authorized individuals must be approved by DFSA and resident in the UAE to ensure hands-on control. The application must include a detailed business plan and operating model description. The firm must show it has adequate financial resources to meet minimum capital requirements, and we'll cover those capital requirements in a separate slide. The formal application involves submitting the core DFSA license forms, along with extensive documentation like in VARA's case, constitutional documents, audited financial if applicable, if the company is operating already, compliance manuals, AML policies, IT security policies, business continuity plans, etc. DFSA authorization team will evaluate the application through an iterative process. So they often come back with follow-up questions or requests for clarification if needed. Once all issues are resolved, the DFSA will issue an in-principle approval outlining any final conditions. And after conditions are met, the DFSA grants the license, financial services permission. That whole process can take 6 to 12 months. And similar timelines are applicable for VARA licensing too. It could even take longer if the regulator has many applications on the table. The licensing fees depend on the scope of financial services and category of license. For DIFC crypto firms, this generally ranges from $15,000 and up to $70,000. The fees double if the group has a multi-layer corporate structure, holding company, or a setup in multiple jurisdictions. Existing authorized firms in DFC that wish to add crypto token activities to their existing licenses must apply for a variation of the permission with a fee of $20,000. And they have expenditure-based capital minimum. Actual capital must be the higher of base capital versus 13 weeks of fixed expenses. DFSA doesn't have token issuance licensing. Instead, it has a token recognition system. Under the token recognition process, any person, issuer, developer, or authorized firm who applies to have a specific crypto token recognized by the DFSA must pay a fee of $5,000 per token for DFSA to review and if criteria are met, added to the recognized crypto tokens list. And general crypto token recognition criteria would include a regulatory status, which means they will evaluate whether the token recognition and regulatory status in other jurisdiction has been registered and recognized. Transparency matters, so clarity regarding the token's purpose, protocols, consensus mechanism, governance arrangements, and information about key stakeholders will be evaluated. Also, the size, liquidity, and volatility of the market for the token, the adequacy and suitability of the technology used in the token's operation, and measures addressing governance, legal and regulatory issues, cybersecurity, anti-money laundering, market abuse, and other financial crimes. So if all those criteria are satisfactory, the DFSA would add the token to the list of recognized tokens. That was all on the DFSA. Now we are moving on to the Financial Services Regulatory Authority in ADGM, which regulates virtual asset services by requiring specialized authorizations for activities like dealing, custody, exchanges, with a strong focus on technology governance, anti-financial crime, and investor protection. So ADGM is also a free zone. It's in Abu Dhabi, and FSRA, it's the ADGM's independent regulator. So to be able to apply for FSRA license, you would need to be set up in ADGM, Abu Dhabi Global Markets Free Zone. And here we have the activities that are offered by this regulatory authority. Only accepted virtual assets, those assessed under FSRA's rule books, based on the traceability, security, market profile, are allowed for these activities. So basically it has a similar to DIFC model where it adds the tokens to a recognized list for activities that are subject to licensing in this licensing authority. Now, the application requirements and licensing process also is similar to the previously reviewed. The pre-application engagement includes the early engagement with FSRA to discuss proposed business model, detailed technological demonstrations, and regulatory planning. The formal application includes a completed virtual asset application form, a detailed launch plan outlining operational and compliance steps, and payment of application fees. And the approval phase goes in two steps. In principle approval, where the FSRA is satisfied with the applicant's readiness and plans, and it issues this in principle approval. And then the final financial services permission, which is granted after conditions are met and operational readiness is verified, possibly including third-party system verifications. Now, on the fees and on the capital requirements. The capital requirements are calculated based on 6 or 12 months of operational expenses of the applicant. For certain activities, which you see on the left side, the requirement is equivalent of 6 months of operational expenses, and the two activities which are of a higher risk, the minimum paid up capital is equivalent of 12 months of operational expenses of the entity. Application fee also vary depending on activity complexity and whether custody is included. FSRA also charges registration and supervision fees, and they don't really have a publicly available fee schedule, but they provided an example of calculation of their fee, which you can see on the screen. Additionally, multilateral trading facilities using virtual assets are required to pay a trending levy to the FSRA on a sliding scale basis, payable monthly in USD. The specific levy amount depends on the trading volume and other factors. Interesting that FSRA may also impose additional fees if a substantial additional regulatory burden is imposed, and it has the discretion to reduce or waive all or part of any fees if it considers it fair and reasonable to do so in a specific case. So applicants and authorized persons are encouraged to discuss any questions relating to fees with FSRA as early as practicable. Now, I'd like to also discuss the sandbox regimes offered by those three regulators. VARA has no formal open access regulatory sandbox, but instead, innovation occurs via targeted pilot programs in collaboration with licensed WASPs. Real-world pilots include initiatives like real estate tokenization and other Web3 projects under supervised, controlled conditions. DFSA operates a formal regulatory sandbox via its innovation testing license. That was established since 2017 and is regularly updated in terms of what activities are eligible for that innovation testing license. The tokenization regulatory sandbox, launched in 2025, is part of this regime, allowing firms to pilot tokenized products like tokenized bonds, funds, securities in a controlled environment with regulatory guidance. And the evaluation of the applicants based on business clarity, readiness, and potential policy impact. FSRA does not run a public virtual asset sandbox per se, but offers Reg Lab and Digital Lab as innovation sandbox type initiatives for collaboration between startups, financial institutions, and regulators. These enable testing of fintech and virtual asset models through a close regulatory engagement. So UAE regulators, VARA in Dubai, the DFSA in DFC, and the FSRA in ADGM, have each built strong but distinct frameworks for virtual assets, balancing innovation with investor protection. With the right structuring and early regulatory engagement, projects can successfully navigate licensing and position themselves for growth in one of the world's most forward-looking digital asset hubs. With that overview complete, I'd now like to open the floor for the Q&A. So if you have any questions, submit them to the Q&A box or chat box, and we will try to cover them.
Thank you, Iryna, so much for your in-depth presentation. So the questions are already rolling in. There's two in the chat from Martin Repka and from Jabran Chaudhry. I don't know if you could see it. So there's two already in the chat, and then in the Q&A box. So we could sort of take that since Martin's question came first, and then Jabran's.
Okay. So Martin's question, could we address the part about token issuance a little more? Given that the licensing process is so complex, it would be good to understand how a UAE entity can issue tokens without the need for VARA licensing. Now, Martin, to properly answer this question, we need to deeply understand the type of token, its use cases, you are trying to launch. And basically, from there, I would be able to give you some answer, not a detailed consultation, of course, but maybe some guidance. So if you can submit a bit more information about the token features to the same Q&A box, that would be great. So Jabran's question is, which of these regulators would apply to RAGDAO? Thanks for the question, Jabran. It's a great question. So because Ras Al Khaimah is not covered by Dubai or Abu Dhabi regulators, a licensing of such firms is subject to Securities Securities Exchange Commission. Most probably, if the token or the type of service you provide involves financial services. But to navigate the exact process, the requirements, and whether your activity qualifies for the licensing by the federal regulator, it's best to connect with your Ras Al Khaimah free zone authority, and they will assist you with the preparation process, or you can engage with a legal advisor or a consultant that will assist you through the application process. And again, we would need to understand your activity or your planned token type a bit better to even respond to the question whether your activity requires a license. Now we have anonymous attendee who's asking, how strict are the UAE residency requirements? Is it common to work with nominees, or will projects usually require to hire actual employees? So UAE is one of the strictest jurisdictions when it comes to regulatory requirements. And as we mentioned, both VARA or DFSA in Dubai or FSRA in Abu Dhabi, they have a part of the application process which involves fit and proper test for the top management of the company. And that's where they evaluate CVs, and those top executives must also be resident in the UAE. So I'm not sure whether it's available in terms of the nominee service, but if so, anyway, that person needs to have specific qualifications and specific background to be able to qualify to pass that fit and proper test. So it's probably just worth hiring a UAE resident employee for that role. However, of course, you need to budget in the salary for that employee to be able to maintain that economic substance required to qualify for the license. And Martin Repka provided some additional information to his question. So my question was general. I'm trying to understand the exempt category more closely. Okay, so would this only relate to tokens which are non-exchangeable for fiat in any way? Yes. So the tokens that are redeemable and not exchangeable are fully exempt. So if it's a purely utility token giving access to a service or product and is burned basically after the token holder uses that token to access the service or product, that token would be fully exempt. If you're planning to exchange those tokens to trade on exchanges, that would fall under category 2. And when it comes to VARA, that category 2 for tokens is not subject to full licensing requirements. It's exempt from its own licensing, but you need to use licensed distributors, like licensed VARA licensed exchange or VARA licensed launchpad or VARA licensed broker to distribute, to exchange your tokens. So then that licensed third-party distributor is then responsible for compliance process, for AML CFT compliance when the tokens change hands. I hope that covered the question. If you'd like to learn more about how token issuing activities and token distribution activities are licensed in various jurisdictions, we have plenty free articles on our resource center on the Legal Notes website, dedicated articles to utility tokens, to tokenized real-world assets. Feel free to use those materials to enhance your knowledge in this sector. And now we'll review the webinar chat questions. I have Robert who's asking, I've heard that getting banking services in the UAE as a crypto company can be difficult. Can you comment on this? Obviously, it's impossible to operate without banking services. Yes, Robert, to some extent, because crypto activities are high-risk activities, those companies sometimes face difficulties when it comes to bank account opening. But we need to analyze which entity are you planning to open a bank account for. If your entity is purely involved in software development, then it shouldn't be an issue. But if your company is trading crypto, or it's an entity that issues tokens, first of all, you would need full licenses. Additionally, well, basically depending on the type of service and type of token. And then if all licenses, the commercial license, which is the equivalent of a company registration, and the crypto license by the dedicated regulator is issued, I don't think you will have difficulties with the banks. Because as I mentioned, if you reached to the point where you have sufficient substance to obtain the license, that would be also sufficient substance for the banks to accept you as a client. Next question is from Victor. We have 3 regulators. Do you have a review of pros and cons for each of them? How to actually choose between the regulators? Great questions. Thanks, Victor. I think it really depends on where you want to be based. If you aim to be in Dubai, your choice would be either DIFC or VARA. And VARA is a dedicated regulator which supervises only virtual asset service providers, where the DIFC's regulator, DFSA, also regulates all other financial services in that free zone, in Dubai International Financial Center. Again, their fees vary, their capital requirements vary, and even the strictness of the application process might also vary. So it's really a question on where you'd like to be based and what budgets are you ready to plan for the licensing activity, for the licensing process. So I think those are the key criteria you need to be looking at when you are choosing your regulator. Okay, and I think that's it on the questions. We have one more question from Ryan. Interested in tokenizing funds assets to fin instruments. The question is how best to structure licensing in UAE. Happy to establish and seek local authorization. This includes custody of the tokenized fin instruments. We recently released a couple of articles on tokenizing real-world assets. And UAE is definitely a great jurisdiction to consider. They are very innovative when it comes to RWA tokenization. And the question is how best to structure licensing in the UAE. I think it's a very extensive question that goes beyond the licensing process itself. It would also include the corporate structuring strategies and a deeper understanding of those assets, who's going to be managing those assets, what are the rights of those token holders that you are looking to link to those tokens and to those tokenized assets. So try to schedule a free call with our sales team. Maybe they can give you a guidance on what you need to plan for in terms of the corporate structuring and other steps in the legal roadmap generally to actually fulfill that idea. Okay, I think that are all the questions.
Hey,
And
hi. Yeah, thank you so much, Iryna, for taking our time, and thank you everyone for joining in today. As we have said, we will be sending the recap to your emails. So rest assured that if you want to revisit any part of the webinar, um, you'll get to revisit that. Equally, we'd also like to inform you that in case you didn't join early, we at Legal Nodes are a tech-enabled legal consultancy company for businesses across different stages of growth. So whether you're a startup, whether you're a mature business, Legal Notes is here to enable you to accelerate your growth by giving you roadmap focused legal solutions. So think about the fact that if you want to engage in any legal service, right? Typically, you'd have to consult with multiple, companies, multiple firms, and multiple consultants, right? But however, legal notes act as a one point of contact for 40 plus types of legal tasks. So from incorporation to privacy compliance to DORA compliance. Um, you can leverage legal notes for that service. So feel free to, we'd also be sending this information in the recap email, obviously. So please feel free to check out legalnotes.com. Currently, we're sort of having like a bandwidth issue with our website. However, that will be resolved shortly so that we can accommodate your request if you need to be in touch with any of us. And also feel free to send a message to Iryna if you want to talk to her at irynak@legalnews.com. Please feel free to send us a message anytime you feel you want to. And thank you for taking our time to speak to us. And yeah, we'd be in touch. Thank you, everyone. Thank you, Iryna. Please enjoy the rest of your day. Take care, and we'll see you in the next one. Bye.
thanks, everyone. It was a pleasure hosting this webinar. Have a nice day.
Bye.
Bye.